So as a divorce lawyer, typically one of the hardest things to predict is alimony. While there is not a strict formula for the judge to calculate alimony, it used to kind of be no holds barred. We didn't know what to expect at all. Our legislature changed that, and in 2018, there was a major change to our alimony system, and it was put into a statute that kind of directed the courts as to what they must find in order to give specific types of alimony. So it's been very helpful in advising clients, but it's still not ironclad. In Alabama, in order to get what you call permanent alimony, you have to be married 20 years or more. Permanent alimony is kind of a misnomer because alimony can always be modified. So if the receiving spouse gets remarried, then alimony is going to terminate. If either spouse dies, then it terminates. But also, if the financial situation of either spouse changes, they can ask the court to modify it, even if it is permanent. Now, if you're married fewer than 20 years, you can only get the amount of years that you were married at the time you filed. That is the absolute maximum amount of alimony you can get. So our statute says that the court is always supposed to consider what is called rehabilitative alimony before they consider any further alimony. Rehabilitative is what it sounds like. It's meant to get the other spouse back on their feet financially. So I have plenty of clients who one spouse has worked the majority of the marriage and the other spouse has stayed home with the kids, and they may have a degree that they haven't used in 20 years. They are entitled usually to rehabilitate themselves to where they can at least earn something to support themselves. And that is the most common form of alimony. So the court is supposed to look at, and you have to be ready to present, not only the earning capability of each spouse, but the needs of each spouse after the divorce, the standard of living during the marriage and what they were accustomed to during the marriage, the health of each spouse, how long they're most likely going to work. All of those factors go into a determination about both rehabilitative and permanent alimony. Alimony is a lot less favored than it used to be. I find that if you are married fewer than 20 years, it's a good ballpark to expect usually alimony for about half the time that you were married, if you're entitled to it at all. The other thing to remember is even if you get, say, 2 years worth of alimony, you can still file at the end of that 2 years to go longer if you can truly show the court that there's a need for that. So what if you're obligated to pay alimony and you lose your job and you can't pay your own bills, much less alimony to your former spouse? You have the right to file what's called a motion to modify. So I've had clients who were booming in the real estate industry, and then the economy crashed and suddenly they're earning, a quarter of their income that they were earning at the time of the divorce. What we have to do is go in and immediately ask the court to give relief. Until you file a motion like that, the court cannot change your alimony. So if you file today, but you don't get to court until 6 months from now, the court can go back to the day that you filed, but not before. It's always going to be up to the court to decide whether a change in alimony is warranted. But usually, if you have lost your job or been forced to take another job due to no fault of your own, the judge is going to give you some relief from that obligation. It's so scary to think about the obligations you might have to pay alimony. Are you going to end up paying out more than you yourself get to take home? Are you going to lose everything that you own? There is not a strict formula, but the judges do typically use kind of a combination of formulas from different places, and they look at what you as the paying spouse are going to have as obligations otherwise. So, for instance, if you have children and you have to pay child support, you're probably not going to have to pay as much alimony as you would if you didn't have that obligation. If you and your spouse have investment accounts that earn interest that you live off of, that's going to be considered and probably lower your obligation to your spouse because they're getting more of that account. You almost never are going to have to worry about, a significant chunk of your income being taken due to alimony. The judges are very aware, and the best way to prepare for that is to have a really good projected budget for what your life is going to cost you post-divorce. And when you do that and you prepare that way, it's really great insurance to make sure that you don't walk away in financial dire straits. Alimony is a complicated subject and it gives rise to a lot of anxiety. Contact Empowered Family Law will help walk you through it and we'll get you a good solution.